Good morning, fam. Myself Dodasamy. Today we discuss rules of international law. What are the content will be there in the rules of international law? Other country how they dealing with the business. The other country how they dealing with the political situation. The other country the how they will deal with developed country and developing country. See, two concepts we can elaborate here. The what are the principle of rules and development must political division between the international standards, the hand of state and government has called the United States drop the convention of right to development. The other European country, the United Nation or Canada or Japan or other country, we have strongly opposed this idea. This works right to development has been able to achieve consists of the keeping legal banned instrument among the possible outcomes and the process. See, any country we can oppose to develop the political strong to advise the national economy or keeping legal standards between the country to country, which has established that must automatically leads keeping languages regarding that is could be evaluated the based in consideration of international legal standards through the collaborative process of engagement. The every country through collaborate with the process, whether it technical process, whether it is not technical process, whether it is financials or international standard of any product of manufacturing industries. See which collaborate with the country to country, the exchanging informations or exchanging the product or exchanging the skills or knowledge. So this basically important to process the further engagement or consideration international legal system. Here there is useful explore independently political the various political in the group, the various country the political group is a different category they measurize the various optional under the international law. Right to development purpose of export meeting legal aspect to implementing right to development. If any country implementing the right to rule, which rules the following up the prospective of formulating the development criteria once approved by the working group, the national legal standards of binding in the nature, the what are the standards has to be taken place which has political agenda or political values of international monetary process. The alternative way behind instrument of any involving the new implementation of new legal aspect of country to agreement between the stakeholders of external affairs. The international standards is binding of right to development criteria want to approve the working groups the perspective of implementation right to development drawing proceeding and meeting. They explore the prospect of transferring to development criteria once approved by the working group, which has the whether it is member country or a non-member country. The proceeding legal process, which has a United Unions drop convention right to development, which has a European Union, whether it is the United States or Canada or Japan, and so other countries so on. Like that, the potential has to be taken place, which has key language so regarding this process, which has international legal key system. The all countries should collaborate with drafting the legal process, the whether it is a high value task of implementation right to development, which is constituted of the export mechanism of working group on right to development, where it is 2002 they established between 2010 from that took the way of that while part of position to propose whether it is work not should be treated the further work as set of regional consultants should be opportunity to explore whether it is what is existing treated as would be accommodated right to development issue with either legal system, whether constitutional settings and the institutional settings, the working group achieve the whether it is when it's scope of process which is recommendation the work group seeking information properly analyzed the existing of the process, which has nation system such as guidelines code of conduct, the what are the policy what are the ethics need to follow the whole countries. the member countries, what are the code of principle should drafting set of the most shoot of to right to development. The working mechanism should be could be put into place, such as set of standards, the Saturday preparation task force. This setting is a potential exploitation of option through political making conclusion regarding the legal instrumental mechanism, the absent of formation of certain obligations. The first obligation of the CETA, which is intention initially writing to apply to global partnership, has understanding of development global exporter aspect of right to development. As to process continue to the revaluation of such area must be state obligation treated as established such global relationship or global partnership. Principle of motivation of trade. The every country should motives, they have own intention to do it to any agreement within the country, one or two more state. That international law, no organizational approach, it has to be taken place if it is any other member country to oppose. No international law institution has affected the human rights treated as obligation of institution or the matter of some decision. It is observed that is non-state subject of international law, such as World Trade Organization, Association of South Asians, the World Banks. The entity is a society on party on convention on right to development. The cooperation might be providing for such as done with respect to specialized agency, the International Convention Economic or Social or Cultural Rights or international organizations or code of rights. The international obligations of set of rule, the global partnership, the transferring such area or into the export. What are the such area we need to see here? The theoretical possibility, the move quickly from current state of development of normative standards or prospect right to development to absent of treasury transferring a such area formal, the article of international convention right to development, such as action might not be best interest of advising right to development, warning abstraction rising of nature of such area, the limitation of general convention as tools of international law. After examining the abstract of transferring of reason certain into truly obligations subjects, the part of will attempt to experiment to see what article has to right to develop. The most of the states, the treasury intend to international law, private sector category of the country, the implicated by the draft such area. Such a set of consideration turns the international organizations, the organizations such as Organization for Economic Cooperative and Developments, can be considerable partnership into context. For example, the criteria the which cause a duty and bear on promote the ensuring access to adequate the financial resources. The World WTO as well as bilateral and regional trade reason on as such as North American Free Trade Agreement, the Asian Trade. The purely the country of any country in the methodized have such goals. The special needs and development country, the special needs on block of small islands, such development of as prospect to our debit problems, descent on prone proactive work to earth and country as seems of implementation by subject committed to good governance and development and priority education, purity on regional educations to be need to be taken place. To be refers to making decisions or making suitable long-term perspective would be useless to seeking international convention right to development of behind the country, the international reconciliation and development. The international institutional treasury or international internal government are willing to do it. Similarly, although the private sector ready to commit an investment agreement range of other international agreements, this should be certainly not able not able to taken place, right to development convention, cancellation of bilateral debt in more bilateral agreement to be, we can see it majorly the particular needs of small Iceland developing status also matter for special agreement rather than development and recent productive works youth conventions under the International Labour Organization. Today we have discussed the basic concept of rules of international law. So we can see all the established parameter here. I already earlier explained what are the content will be there, what are the meaning of international law, why it is required, sorry, what are the requirement will be there to international law, what are the member states should